This episode of AHLA Speaking of Health Law is sponsored by Clearwater. For more information, visit clearwatersecurity.com.
Welcome, everyone. My name is Andrew Mahler. I'm the Vice President of Privacy, Compliance, and Audit here at Clearwater. And very excited today. We're talking about a topic that's usually found very high on risk heat maps for anyone working in healthcare and tech. And that's this topic of vendor relationships and data breaches. Really fortunate to have with me today Shaylin Watkins, who's an associate at Holland & Knight. She's truly an expert who brings deep expertise in health law and privacy and the practical realities of working with vendors. She spoke about this topic during a presentation at AHLA's 2025 annual meeting in San Diego, which was called The Complexities of Managing Vendor Relationships, Practical Strategies for Navigating Data Breaches in a New Age of Data Privacy. Shaylin's also the vice chair in AHLA's Behavioral Health Practice Group. In this conversation today, I'll ask Shaylin a bunch of questions about, this topic and leveraging her expertise. We'll unpack how healthcare organizations can better manage vendors, respond to related data breaches, and navigate the evolving legal and risk landscape. From HIPAA to high-tech regs to recent lessons learned from high-profile cases. We're going to get a firsthand look from Shaylin about how industry leaders and their counsel are looking to protect data and manage risk. Shaylin, really, I'm thrilled to be speaking with you, and I just would love if you just start off by maybe telling us about your role and why this topic is so central to your work.
Yeah, thanks for that intro. It actually makes me feel like I'm way better than I am sometimes. So I love that. I work at Holland & Knight and as a senior associate in our healthcare regulatory and enforcement practice group. And a big subset of the clients that I represent, especially are telehealth companies and telehealth platforms, but I also work with plenty of different provider types, hospital systems, health systems, laboratories, and other vendors, which is something that I think is really applicable to the topic we're talking about today. In my past life, as a lawyer before I came to Holland & Knight, I also worked at the U.S. Department of Health and Human Services in the Office of General Counsel as an assistant regional counsel in one of our regional offices. And in that role, I actually represented OCR, the Office for Civil Rights, which is the agency that promulgates HIPAA, which is a lot of what we'll be talking about today. But at the same time, there's so many other things happening since my long stint back in the day with OCR that I think is going to be fun to talk through in this podcast.
Yeah, thanks for sharing that. Just excited to your point, things just seem to change, day to day, let alone, year to year. So for those listeners, and you mentioned OCR already, but for those who maybe aren't as familiar, I'm sure many are. Can you speak a bit about how, HIPAA shapes an organization's, responsibilities related to managing vendor risk?
Yeah, especially for large organizations, HIPAA is usually the first thing we're talking about because it transcends state lines, right? We're talking about anyone who is involved in a healthcare organization for the most part. And if you're billing insurance or you're getting some sort of federal financial assistance through your practices, or if you're contracting with someone who's a HIPAA regulated entity, you're going to fall in this bucket requiring you to have HIPAA compliance. And I think for large scale, when we're talking about just creating a compliant health system, privacy and security becomes a huge chunk of that because HIPAA violations, as you know, Andrew, and we work with Clearwater all the time in our firm, our clients realize that there's a big financial impact if you have a HIPAA violation. And sometimes that financial impact can get up to treble damages. Also, an investigation when you're dealing with HIPAA regulated entities can get so intense. It also involves sometimes, grander consequences like referrals to other agencies, OIG, DOJ, and even sometimes to CMS, which could put Medicare funds at risk. And for a lot of these organizations, Medicare and Medicaid are some of the highest payers that are coming in to their organizations. So it's really important and critical that we're thinking about the most important element of some of this, which is always kind of comes down to privacy and security. And I think another thing that makes HIPAA so critical these days is the fact that we're kind of in the age of this kind of new tech wave, right? You know, you watch TV and there's always a hacker of some sort. There's a robot that can do anything and everything. We know that none of us could probably live without our smartphones in our hands. We just have so much more access and ability to get to things, which makes it everything that we're doing a higher risk for those who might be looking to fish out really protected information. And likewise, when we're talking about kind of why HIPAA becomes the backbone of a lot of our compliance issues, it's because then every state, for the most part, has its own kind of baby HIPAA law that, you know, has a little nuance about what needs to be happening. And then even outside of the baby HIPAA laws, there is now this new wave of health data information privacy laws that is sweeping the nation, right? You know, you go to Colorado, you come here to California, and many other states. Data privacy is so critical that states are also looking to show examples of why they're creating these laws. And so their enforcement metrics are just really high priority right now.
Yeah. Yeah, and to your point about privacy, I mean, in this world of data sharing and, you know, whether it's, you know, data sharing related to, you know, interesting tech or for, you know, your robots running around your house or your city, or data sharing for, you know, other types of reasons, it just that risk just continues to evolve as we're, you know, living in such an interconnected world. And, you know, I know that, you know, again, many listeners probably familiar with the concept of business associate agreements, but, you know, can you talk a little bit about how that, you know, fits into vendor management and maybe some of the most common pitfalls you see in BAAs, whether it's drafting or acceptance or negotiation?
Yeah. So I think the BAA is the thing that is the first thing we all want to look to in any situation, whether you're a regulator, you're a party to the BAA, you're an outsider who wants to maybe purchase a company, you look to see what are your obligations in the event of one of these inevitable breaches. And because of that, I think that's kind of why BAAs become a critical point here. Now, there's also the fact that HIPAA requires you to have a BAA, right? So I would say when you talk about pitfalls, if you're a covered entity and you don't have a BAA in place, but you're giving out information to any of your, you know, business associates, then you're already in violation of HIPAA, and therefore we have a big red flag. So not having the BAA is probably one of the biggest pitfalls. But I'm seeing that less and less often. In fact, sometimes I'm seeing the converse where some people just slap a BAA on everything. And there's times when you don't need a BAA at all because you're not actually transmitting any protected health information. And so I think a big thing that we discussed in our presentation was the pitfalls that happen in the middle of that spectrum, the over BAA to the under BAA area. And for basic understanding, a business associate, for the purposes of this discussion, is anyone that a covered entity or another business associate is sharing protected health information with. And to remove nuance, I'll just make it kind of simple. For the purposes of carrying out the business that that is being organized under the service agreement that's overlying. And one thing we really noted was an incomplete BAA is just as bad as a non-existent BAA. And furthermore, a BAA that hasn't been updated is sometimes just as bad. These are some of the biggest things that we're seeing with our clients because, you know, if you have an ongoing relationship with a party who's your third party vendor, and you've had this relationship for 20, 30 years, and HIPAA and high tech undergo, revisions, you might be missing some new changes. For example, as lawyers, we try to keep up to date and tell our clients, but there's a point in time where we're like, hey, there's about to be a new MPP requirement rolling out in 2026. So we need to make sure all of our clients are aware that there's this new requirement for updating your notice of privacy practices. And because of the fact that you have to be up to date with different changes that are happening over time, it's really easy to forget to add those review cycles in your day to day if you're in-house. It's easy for me to put out another article and say, hey, don't forget this is happening. It's easy for me to call my clients and say, oh, by the way, I saw this. But the inner operations of an organization, sometimes you're not really thinking about some of the mundane. And back to the idea of an incomplete BAA, there are some times where we've seen that the BAA won't necessarily address all of the different circumstances as to which data might be transmitted and or lost inadvertently or purposefully. And that leaves a gap when you're actually face the data breach, right? So something happens and the BAA doesn't address that situation, and everybody's got their hands in the air and like, whose job is it to deal with this? Is it the business associate's job? Is it the covered entity's job? When was notice required? Little pieces of the puzzle that are critical when you get to those big breaches, which I'm sure we'll talk a little bit about.
Yeah, and I agree with you. I mean, we frequently see, incomplete BAAs. We'll see BAAs that, haven't been updated to comply with HIPAA, but some BAAs that haven't been, I think to your point, updated to even really reflect what the services are. And then we see some cases where, the maybe the business associate has drafted their own version of a BAA and is allowing themselves to do a lot with the data that maybe the covered entity no longer feels comfortable with. We see, things like the business associate can de-identify, PHI for its own purposes. And, some might argue that may not be a legitimate, purpose of a business associate relationship. And so we see that too. So I think, kind of as not to jump too far ahead, but I think as we sort of are talking about best practices at the end. I mean, I think this is just one that probably will, flow throughout the conversation today. It's like, are you reviewing it regularly? Do you really feel comfortable with your template? Do you feel comfortable with your agreements? Is somebody on point, particularly for those high risk, vendors with lots of data, lots of PHI or sensitive information? So I think really.
Yeah. And I even plug in here too. There's the idea of the DPA, right? And having the data agreement as well, which are usually attached. And I think one question that you kind of rose is who's supposed to draft this? What party is supposed to be responsible? Typically, vendors are the ones who have it because they're the one who are giving out their services so regularly. But if you're not negotiating that appropriately as the covered entity, really this is your data and you're on the line. So you should be either having your own standard BAA or heavily negotiating every BAA you receive, even if it's standard for the vendor.
That's right. Yeah.
And I kind of laugh sometimes when I think of those kind of frivolous clauses where the vendor is asking to do a little bit more with the information than is necessary. I think that goes to kind of my original point, right? One thing that you shouldn't be doing is collecting information that you have no need to have. So one of my biggest pieces of advice for privacy with even my providers are, do you need this PHI? Why are you asking for it? Perfect example, if I'm representing a dentist, maybe it is important for you to know if your female client is pregnant or not, because it'll help you with your assessment protocols. However, do you need to know the last date of her menstrual cycle? Mm-hmm. Is that helpful for what your practice is doing? And to the same point, for vendors, is it helpful for you to be collecting information that you don't necessarily need for even your internal, services that you're providing?
Yeah. Do you want that risk? Do you want to carry that? I mean, I think, Yeah, whether it's and as I was hearing you talk, I was also thinking about, downstream business associate relationships too, because you think, I mean, the covered entity has, really the ultimate responsibility here, but I'm sure you have lots of clients that are business associates who then share data with other business associates, and there's responsibilities there that, as those kind of responsibilities flow down the chain. I mean, it's whether or not you're a covered entity or a business associate. I mean, these are, I think your words are applicable across that ecosystem.
Right.
Yeah. So, you sort of, I think, briefly, you kind of touched on some of I think you said, some of the baby HIPAA laws, which is my new favorite phrase. But if, your presentation, you talked about, the FTC health breach notification rule, as well as some of these state level privacy laws, like, of course, people are familiar with California and more familiar with Washington, what's going on in Washington. Can you talk, speak a bit about, are there differences in approaches related to those state laws? Are you encouraging clients to add certain provisions or remove provisions based on, what we're seeing at the state level?
Yeah, that's a really good question. One thing I love about working in Holland in the Night is that we also have our own data privacy team that I get to work closely with, because they get even more into the trenches with some of these state data privacy laws than I do. And it is a full-time job at this point, especially you look at the Washington My Health, My Data Act. It is kind of the archetype for everybody who is coming out with a new law. And I think in our presentation, we highlighted various states that had pending legislation of the like. And what I've come to realize is the most important piece for us as lawyers when we're advising clients and thinking about state level implications is making sure that we ask the question on the front end. Where are you providing services? Where are you collecting data? Because sometimes the answer is, hey, I'm not doing very much business in Washington at all. And so then maybe I don't need to have a very stringent, part of DPA or agreement or any type of set of protections that, complies with the Washington My Health, My Data Act, which is it's a long haul of work. But then if we never ask the question and we find out a substantial amount of, data is being collected in California, Washington, we are behind if we haven't already addressed that. So it's about first having that initial analysis, asking where's the data being collected from, what is the purpose of the data usage, how many individuals is their information being collected, and then creating privacy policies and having other elements of governance that will ensure that your organization is compliant with all the applicable laws. To that same point, right, that also usually means that part of your public facing policies, not just your internal policies, your public facing policies are going to be impacted, right? Both California and Washington require certain notices to be available for their consumers to see, for example. So that's why it's important to have counsel that is really up to date and knowledgeable about these things. To work with consultants like Clearwater that understand, the impacts of what happens if any of these provisions are being triggered. Because if you do the due diligence on the front end, if we just assume the breach is eventually going to happen. Hopefully it doesn't happen tomorrow. Hopefully it doesn't happen regularly. But if you just assume the breach is going to happen because it's inevitable, confirming that there are no holes or avoidable incidents in that breach, I think becomes the critical piece. And so to that same point, we touched a little bit on the FTC health brief notification rule, which is almost the harder thing for me personally to wrap my head around, because there's a lot of questions about if something was given with or without authorization. We were talking about really the nuances between when this rule is triggered versus dealing with just a breach notification under HIPAA, for example. And I think at the end of the day, what I've seen in practice is you're going to play a catch-up game if you haven't already analyzed these things on the front end. Um, One thing we don't talk about enough is the importance of risk analyses, right? So we talked about updating our agreements and managing, and as part of our managing of relationships. And, I typically tell my clients at least once a year, you should be looking at those agreements. But to the same point, you should be doing your own risk analysis that usually includes the review of your agreements, right? And completing that risk analysis to see if those holes exist, not just within your organization, but with your downstream vendors is very, very important.
Yeah. Yeah. And I mean, part of that is, when you think about your risk analysis, you also think about your, data privacy or data protection impact assessments that many of these state laws and GDPR and others require, where forces you to look at the data and, where are you collecting data? Where are these patients or consumers or others based? And I think, I mean, not to, put too fine a point on it, but we frequently will hear, I mean, maybe not as frequently as we used to, but hear from startups in particular and emerging, health IT groups who would say, gosh, we'd love to have all the data. Can we work with our clients and just get all the data we can so that then we can figure out what we want to do with it? And maybe there's some legitimate purposes for that, depending on the circumstances. But we always tell people, I don't know that you know what you're asking for, right? Because even if you have a relationship where there is more free-flowing data and there's a legitimate purpose for that and there's the controls in place, to your point, if and when there's a breach, are you really sure you wanted this biometric data that was just cool to have just in case? Maybe you didn't, maybe you don't need that.
Right.
Because may trigger reporting notification. You may get you may have a regulator asking questions, you may have news reporters asking questions, and all of that just because you thought it would be cool if we collected the data and maybe we'll use it down the road. That's a big risk.
Yeah, and even for clients like that, I love working with startups because they're always so innovative, right?
That's right.
And they're always on the cutting edge of things, but you almost have to sometimes hold their hands and say, hey, maybe we don't need it right now.
Right.
But if we do think we need it in the future, it's not hard to amend this agreement
Right.
and pull that information. Why hold on to it in perpetuity, if we're not sure we need it right now? And for our listeners, sometimes what I've seen, the reason why clients really kind of think that the idea of capturing large amounts of data would be great, it leads to this kind of marketing-ish deal, where they kind of want to be able to reach more consumers, reach more patients, which becomes a whole nother slew of problems.
Yeah.
And I think kind of gets us into some of the big breaches that we've seen, or the big, namesake cases that we've seen happen over the last few years.
Let's maybe talk a bit about this. So, we've talked about, I think you've shared a lot of insights about some of the regulations, the rules, whether it's HIPAA or state level or FTC health breach notification. But maybe let's talk a little bit about legal risks and what you're seeing, in sort of the sort of, whether it's the class action or kind of general sort of courtroom setting. And your presentation, of course, hard to talk about this, this day and age without reflecting back on, what's happened with Metapixel and what's happened with Change Healthcare. And those are just two, as you know, among, a growing list of organizations that are on the receiving end of class action complaints and other sort of initiatives. So we'd just love to hear from you. Could you talk a bit about the trends that you're seeing, in terms of just legal risks and maybe also, defenses and things that you've seen that seem to be working well, just as you're kind of doing, in your presentation, did a great job of this sort of survey of the legal risk landscape.
Yeah, and I'd be remiss if I didn't mention that I had two really great co-presenters as well in this presentation. And so Maria did a really good analysis of the economic and financial impact of data breaches, which I think is the first risk, right? It is the damages portion of these breaches. You know that damages being calculated is the first thing your client's going to hear and understand before anything else. And I think she ascertained that I think in 2024 was about $4.9 million had been the average cost of a data breach on large scale data breaches. So that was already shocking to me. And I think that that's enough usually to catch a client's ear. But when we talk about some of the cases that we were seeing, and I think we kind of introduced the idea just now when we're talking about capturing large amounts of data. Google Pixel was kind of one of the first hits that we were receiving. We were like, oh my goodness, what's going on? And even to this day, Google Analytics is free. Clients love to use it because it's free. But Google is also still collecting a lot and a lot and a lot when you're using it. And that's hard. That's hard to really navigate around for clients. We try to do simple things like make sure that the pixels aren't sitting on every single landing page on their website, that that they're only applicable when necessary. Because once you've given it away inadvertently, it's gone forever, and you end up in this big class action world, which I think is also what we're seeing with Change Healthcare. Kelly, my other co-presenter, she is in-house at a health plan, and she was able to talk about the real world impacts of the Change Healthcare litigation. Both Google Medical Pixel and Change Healthcare showed us that the plaintiff's bar is not afraid, to gather as many plaintiffs as possible in these scenarios. And I think with the creation of these new even state level laws, we're seeing even more of that, right? You're getting more causes of action as available options for plaintiffs. It's no longer just trying to find ways under HIPAA, where we were like, oh, well, there isn't really a private right of action. We're now seeing that there are multiple different avenues for plaintiffs to initiate litigation. And what Kelly spoke pretty well about was that in her organization, they realized that the reason why they ended up as part of the Change Healthcare ordeal was really because they hadn't updated their agreement with their vendors. And their data ended up being kind of sunken in as part of one of those big ominous data pools. And there was the next risk of, once they were identified as being part of all of this, they didn't know whose job it was going to be to do the requisite reporting until, it was finally determined that Change Healthcare was going to have to do it for everyone. At some point, these organizations were just scrambling because this was all happening. It happened without them knowing what was going to happen. Everyone has an immediate responsibility to do the necessary protocols, do their own internal investigations, determine what their risk profile is. And when you're behind the ball like that, then you're also thinking about the fact that you now have notification requirements, which could be not only under HIPAA, right? You're thinking about notifications to the individuals, to the media, to the department, but then you're thinking about what are your other requirements under other laws, whether they be the state laws, whether it be if the FTC breach notification rule applies, which also requires some of those large, notifications. Another thing to think about is that, and so the cost of those notifications was a big point of negotiation for most everyone. Another thing to think about is that you're thinking about the cost of being a part of the litigation and settling the litigation. Not just the cost of the damages that you have encountered by being a part of the data breach, but of making whole, quote unquote, the plaintiffs or the affected individuals. When you're dealing with just an enforcement action, you're not really thinking as much about it. But when we're sitting in litigation, your number isn't just is it's not just that original damages number, it's and more. And so I think one of our big lessons learned was, you know, leveraging your desires as the covered entity with that of your vendors, is it requires a special touch. It requires you to have people who are on the ground, who are willing to be in constant communication with your vendors, who are willing to ensure compliance from your vendors. No one likes to be the watchdog, but in this day and age, if you're thinking about the average number being in the millions of dollars for a data breach, you want to kind of insulate yourself from that risk. And that's without thinking about what the attorney fees are going to be. That's without thinking about, what happens when you have now to overhaul your security and your privacy group. When you have to put in new frameworks, it costs a lot more on the other side. We didn't really get too much into to great defenses, because I think if we're honest with ourselves, we have to say a data breach, considering that the fact that we're going to assume they're inevitable, there is no defense to the idea of violating or improperly protecting and securing information to the level that is required by law. The idea is that if the breach is going to occur, so long as you are in compliance with the requisite laws, there should not be any real risk to the organization, because we assume the breach will occur, and that's why the law exists. And so the caveat there is if you're in compliance, and being in compliance requires that watchdog mentality of our clients. And that is a mentality we haven't had to have for so long. And now that we have things like AI that are just embedded in our systems that are helping us get our jobs done, we have to be on top of it. We have to kind of be forward thinking. It wasn't to blame anyone within the organizations for their personal failings at that point. It was the fact that the organizations had failed to keep up with what was happening and what was going on. So I think ultimately the only defense that we really heard was, hey, it's not my duty to deal with this. It's Change Healthcare's, right? Whose job is it? And that gets me back to one of my favorite rules I always tell clients when they're negotiating their BAAs is be very clear. Be very, very clear on whose duty it is to do all types of diligence, whose duty it is to do specific reportings, so that you're not pointing the finger in the middle of the crisis. It's also important if you want to talk about ideas of indemnification of sorts, right? Who's paying for the cost of those notifications or the necessary and requisite compliance with any notification requirements? Those are things that can be written into the agreements that can insulate those risks instead of defend the risk, right? You're insulating yourself from some of those risks. And I know Kelly spoke a little bit about some of their agreements had that kind of indemnification while others did not. And so when we're thinking about how complex these relationships can be, those are the things that we want to be looking at and keeping updated and thinking through, just as much as we want the terms of the services and the data collection to be up to date.
Yeah. No, and that's, I think, really helpful, and I think very insightful. I think we're getting into the best practice part of this conversation, but really quickly before we do that, just wanted to mention that so you mentioned the average cost of data breach was 4.9 million, and when I was looking at the slide deck, I think this comes from IBM's data breach report from last year. I think important to note since this is an AHLA podcast, we've got or video, whatever we're doing these days. Lots of folks in healthcare, listening, watching. the average cost was 4.9, but the healthcare industry overall averaged 10.9 million per data breach. So in terms of just costs, I mean, not insignificant, right? Particularly for health systems that aren't prepared to manage this. So, I appreciate you all sharing those data points. And, thinking about best practices and kind of as we're starting to, maybe wind down the conversation, I think something you said that really resonated with me, like, so Clearwater, we do a lot of work with our clients, helping to perform vendor risk assessments. We're reaching out to vendors on behalf of clients. We're helping to collect data, helping them do some of that, that ongoing risk management. I would say in most cases that works really well. We have there always is a percentage of vendors that are either non-responsive or they're vendors that are huge. Google's, Amazon's, Oracle's, Cerner's, Epic's, who may be responsive, but their response is, take a look at this link because here's where we've posted, information about our risk analysis, or here's where we've posted information about, our high trust work or whatever work they've been doing. And we don't have in both of those situations, so non-responsive vendors, unresponsive vendors, and then these huge vendors, we don't have that kind of interaction that we would like to have. And I think something you said and about doing some of this work up front, I think is really important because, at that contracting stage, you do have this ability to ask these kinds of questions of your future partner. It's one thing to say, let's negotiate the BAA together, but it's another thing to say, hey, we're going to have to be doing some oversight. We want to make sure we have a process with you so that we know who we're calling or emailing, or we understand what the sort of requirements are up front, so that if it is, an Oracle and they say, look, we don't answer vendor questionnaires, but here's our process, that organization can make a decision, if that's the right fit for them. Obviously in some cases it's sort of unavoidable, but yeah, I just really, I thought it was worth kind of extrapolating that a bit because I thought that was a really helpful point you made. I don't know what other, when you think about clients, whether they're business associate clients or covered entity clients, what sort of best practices are you seeing and recommendations, are you making to, whether it's general counsel or compliance officers? Just curious your thoughts.
Yeah, so we came up with three of our best practices that we wanted to highlight for those who watched our presentation. It was, as lawyers, first, make sure that your client really understands the contract and the deliverable that's coming with that contract. And I think that kind of goes to the point that you were just speaking about, right? And it's about the questions asking phase. It's about really diving in, and even if it's just between you and your client, you initiating conversation about the holes you're seeing so that they can really kind of appreciate what's happening and what's not happening and what might be necessary. Second, we can do better by empowering our clients to work with their vendors directly on privacy issues. It kind of creating that watchdog, that oversight that we've been speaking about throughout this podcast. Embed someone as a liaison for your vendor relationships, right? And let it be that it's a natural conversation. Maybe they do check-ins monthly that are not necessarily, the stringent, hey, produce X, Y, and Z to me, but just the basic understanding. Is the vendor willing to let you come and understand their operations internally? Just start those kind of natural conversations, because when the relationship becomes a little bit more tense in the data breach world, you're going to get a lot less hands-on time with them. And then the third thing we came up with was considering a demo or meeting with the vendor. And when you do that demo, your legal team and your privacy team should be there. We didn't really talk about this, but sometimes it's that, especially with our kind of smaller clients, our startups, they go have the meeting, they sit down, they talk about it, but the right people aren't in the room to kind of assess what might be next or what's practical or impractical for the organization in the whole. So Kelly talked a little bit about it, whereas now her team, they always have privacy in the room on certain situations. And it's a non-negotiable. The meeting cannot happen unless they are there. And I think that's a good kind of rule of thumb to have when we're talking about things that could impact privacy or security. To have the people who need to be in the know at the table. Don't just create a policy or a procedure willy-nilly, and then impose it on them, and then they come back and tell you, well, that's not even practical. We couldn't even do that. I recently had a client, come to me and say, hey, well, Google won't sign our BAA. And I said, yeah, well, Google doesn't sign anyone's BAAs. That's something we could have easily told you, on the front end of things, that wasn't going to be an option for you. And that's why, these are the risks that we're trying to navigate around. And it's not worth your time trying to get me to negotiate with them because they're not going to do it. That's a practice we've learned. So I think those were kind of our three big pieces and takeaways. I think you add that to our list of things to be thinking about when you're negotiating the agreements and keeping them up to date. You're in a better spot, and have knowledgeable counsel, have good good relationships and rapport with consultants that really understand what's going on. I know I'm always happy when my client, is willing to engage Clearwater. We're just like having it's so much easier to be on one page and just be thinking through these things together on the front end of things, because we almost never end up with a problem. And especially when you get to the acquisition phase, you're dealing with startups and they're really ready to sell off. You're in a much better phase of life, right? And you're much more attractive to investors when everything's already in tip-top shape.
Right.
There's no risk for them to acquire.
That's right. You can say we've got risks and we're managing them, and we've got, these people supporting us, and whether it's, Holland and Knight and you or others, you can say we at least know what the risks are, and we're dealing with them. We're sort of managing it, and vendor risks are, yeah, it's like it's not going to go away. It's
Yeah.
just how do you manage it? What's the process? And do you feel like, you're just sort of taking it a day at a time to help, make sure your program is in, sort of moving towards maturity. Yeah. Yeah. Well, it's been really great talking with you, Shaylin, and really, like I said, I mean, really appreciate the insights both from the presentation with your other presenters and then talking with you today. Yeah, I guess I'll just in the case you have any final thoughts, just turn it over to you. But just again, thanks for your time.
No, thanks so much for talking with me too, Andrew. It's always good to talk to you. I can't wait to see you soon, hopefully. And if not soon, then I better see you at annual meeting next year. I heard it's exciting because it's coming to New York City for the first time in forever. So I'd love to be in Manhattan talking about all this with you in the summer of 2026.
Let's do it. That sounds great.
All right,
All right,
sounds good.
thanks, Shaylin.